Hello and welcome to the Analyst dated 13th July 2023 by Vajiram and Ravi. In this, we'll be covering the current affairs articles from both the Hindu as well as Indian Express newspaper, and the handout of this very discussion would be provided to you in the description below. Let's have a look over the articles that we are going to cover today. So firstly, we'll be looking into the issue of judicial appointments. Then we'll try to understand the concept of constitutional morality. Then we'll try to understand that why, when it comes to the autonomy of ED, it's weakening. Then we'll try to understand the concept of consumer price index, and lastly we'll try to understand the concept of virtual private networks. These last two articles we'll be covering from prelims perspective, the rest three we'll be covering from mains perspective. Let's begin. Now the first article relates to judicial appointments. What is the context? The context is, recently the President has appointed 2 new judges to the Supreme Court. Now in this regard, the first thing that you need to understand is Article 124 subclause 2. What is this article? This article states that the judge of the Supreme Court shall be appointed by the President after consulting as many number of Supreme Court as well as High Court judges as he may deem necessary for this purpose. Now, there was a lot of controversy with regard to this word consultation, which we find mentioned under this article. So, through various Supreme Court judgments, the judiciary interpreted this word consultation, which we find mentioned in this article. We'll try to understand that how the judicial interpretation of this term changed over a period of time by taking a very simple example that, who is going to have the primacy when it comes to the decision for your marriage, whether it would be your parents or you. Okay, so let's try and understand the evolution of collegium system. Now in the first judge's case, which is popularly known as S.P. Gupta versus Union of India case 1981, in this judgment, the Supreme Court stated that the word consultation merely refers to exchange of ideas between the CJI and the President. It does not imply concurrence. So let's refer to the example from your life. When it comes to taking decision with regard to your marriage, you would be exchanging views with your parents. Okay, there would not be concurrence when it comes to your parents' opinion. Now, in the second judge's case, the Supreme Court, in Supreme Court Advocates on Record Association versus Union of India case 1993, stated that the word consultation implies concurrence with the CJI. Now, this implies that there would be primacy of the CJI when it comes to judicial appointments. And in this regard, CJI needs to consult 2 senior-most judges of the Supreme Court, and this consultation needs to be done in writing. So it implies that CJI alone cannot recommend a name of a particular judge to be appointed as a Supreme Court judge. In this regard, he needs to consult 2 senior-most judges. Okay. So now let's take the example again of your marriage. Now this implies that your parents would be having the final say, and while taking that decision, they would be consulting your grandparents as well. Okay. And with regard to the appointment of CJI, in this landmark judgment, that is the second judge's case, the Supreme Court stated that only the senior most judge of the Supreme Court alone could be appointed as CJI. Why is what so? Because in 1973 and in 1977, the executive misused its power when it comes to the appointment of CJI. What exactly happened in these 2 years? In 1973, A.N. Ray was appointed as CJI, superseding the 3 senior-most judges of the Supreme Court. And similarly, in 1977, M.U. Baig was appointed as CJI, superseding the then senior-most judge of the Supreme Court. Therefore, in the second judge's case, the Supreme Court clearly stated that when it comes to appointment of CJI, only the senior-most judge of the Supreme Court could alone be appointed as CJI. Okay, this was regarding the second judge case. Now, in the third judge's case, the Supreme Court stated that the CJI needs to consult the plurality of judges. That is, in re special reference 1998 judgment, the Supreme Court stated that CJI needs to consult 4 senior most judges of the Supreme Court. Now, let's again go back to your example. That means that when it comes to taking decision with regard to your marriage, your parents would also be consulting your family members apart from the grandparents. And again, this consultation would be done in writing. And furthermore, in this third judge's case, the Supreme Court stated that if out of these, 4 members, even if 2 members gives adverse opinion with regard to a particular judge, then the CJI cannot move forward with the recommendation of that particular judge. Okay? So, this was the third judge's case, and which ultimately streamlined the collegium system that we are witnessing today in India, okay, with regard to judicial appointment. Now, let's look into the issues which are there with regard to this collegium system. First major issue is it is an extra constitutional system, because we do not find mention of this collegium system anywhere in the Indian Constitution. It was rather a result of the judicial interpretation of this word consultation under Article 124 subclause 2. Okay? So it is a result of judicial innovation. It is not mentioned anywhere in the Indian Constitution. Then it is against the system of checks and balance, because through these different judges' case, the judiciary has basically, kept all the powers when it comes to judicial power, when it comes to judicial appointment in his own hand. Executive have no say when it comes to the judicial appointment, which goes against the principle of system of checks and balances. Because nowhere in the world the system is there that judges appoint themselves. Okay, there is the say of the executive when it comes to the judicial appointment. Then it is a closed door mechanism. The public do not know that when the collegium system meets, how they arrive at a decision, and on what ground they basically recommend a name of a particular judge to be appointed as a Supreme Court judge. So it is quite opaque. Okay, there is lack of accountability when it comes to the collegium system. And this is the reason that we are witnessing unequal representation when it comes to the representation of female in the higher judiciary. In Supreme Court, we only have 4 female judges, while only 11% of the judges in High Court are female. Okay? So, on account of this opaque system, what we are witnessing? We are witnessing nepotism, favoritism, which is ultimately leading to unequal representation. Let's have a look over the appointment procedure in other democracies. For example, in US, the judges of the federal court are appointed by the president with the advice and the consent of the Senate, which is the upper house there. And in UK, they have an independent judicial appointment commission to carry out the judicial appointment, to recommend in this regard. That is why I told you right now that nowhere in the world we have this system that the judges appoint judges. Okay? Now, the next aspect that we need to know is NJAC. In order to address the issues that we were witnessing with regard to collegium system, the government of the day introduced 99th Constitutional Amendment Act in 2014, which talked about creation of a National Judicial Appointment Commission, which would be, recommending the president with regard to the appointment as well as transfer of High Court judges from one High Court to another High Court. Now, this NJAC was supposed to be a 6-member body. 3 members would be from judiciary, 3 from the executive. When it comes to judiciary, there would be CJI, who would be the chairperson of this commission, and it would consist of 2 senior most judges of the Supreme Court. And when it comes to executive, it would be having Union Law Minister and 2 eminent persons who would be appointed by a committee, which would be consisting of Prime Minister, Leader of Opposition in the Lok Sabha, and the CJI. Okay? Now, this was the composition. But the Supreme Court in 4th judge's case, which is popularly known as the NJAC judgment, in 2015 struck down the 99th Constitutional Amendment Act. Why? It stated that judicial appointment is the basic facet of judicial independence, which is a part of the basic structure. And judicial primacy, please note this term, during the selection process is also a part of the basic structure. So in this judgment, the judiciary stated that the collegium allows for executive participation while maintaining judicial primacy through the collegium. The NJAC violates the basic structure by doing away with judicial primacy through its veto provision. So, the Supreme Court basically struck down this NJAC Act, stating that it is going to undermine the judicial independence. Let's have a look over the other arguments which were given by the judiciary in this 4 judges case. Justice Kheher stated that if we give executive primary stay when it comes to judicial appointment, then we would be witnessing a culture of reciprocity. What does this imply? This implies that judges would develop a feeling of paying back to their political masters. And ultimately what would happen? The judicial appointments would be affected by political considerations, which is not good for the independence of judiciary. Then another issue, as I've stated here, the veto provisions. What was this veto provision exactly? If any 2 members of this NJAC gave an adverse opinion with regard to a particular judge, then the NJAC cannot move further with the recommendation of that particular, so the name of that particular judge. Okay, the same that we witness in collegium system as well. Now, why the judiciary was worried with regard to this veto provision? Because the judiciary stated that it might happen that these 2 members misuse their veto power to strike down an otherwise valid appointment. And they were also worried that what would be the procedure of removal of these 2 members of the NJAC if it is found that they are misusing their veto power. Furthermore, in this NJAC Act, the 2 eminent persons which were to be appointed as the member of NJAC, they need not have any expertise in law, or they need not need to be aware of the functioning of the courts. Okay, so in this regard, the judiciary again raised concerns. Finally, we need to understand that what is the way forward given this scenario. In this regard, National Commission to review the working of the Constitution, which was headed by Justice Venkatachalya, recommended the establishment of a National Judicial Commission, which would be consisting of 5 members. Okay, it would be having CJI plus 2 senior most judge of the Supreme Court, and from the executive side, you would be having Union Minister of Law and 1 eminent person, which would be nominated by the President after consulting the Chief Justice of India. So it basically ensured primacy of the judiciary in judicial appointments. So in order to ensure the primacy of the judiciary when it comes to judicial appointment, this National Commission to review the working of the Constitution recommended the composition of this National Judicial Commission. What more could be done? The judiciary and the executive needs to finalize the memorandum of procedure when it comes to judicial appointment as soon as possible. Okay, and we need to streamline the selection procedure of the judicial appointment, and we need to ensure that there is an effective system of checks and balance and the procedure is transparent in nature. Now, whatever we have discussed would be useful for you to address any question if you get with regard to judicial appointments and the reforms in judiciary that are required. This is all with regard to this article. Let's move to the next one. Now, the next article relates to constitutional morality, and it relates to this very topic of your GS paper 2 syllabus. Now, first thing that we need to understand with regard to constitutional morality is, how do you define constitutional morality? Before I tell you the definition, I need to be very explicit here that nowhere in the Indian Constitution you find mention of the definition of constitutional morality. This concept was given by Grote, And according to Grote, constitutional morality basically implies that the citizens and the government needs to adhere to the core constitutional values of the Constitution. The citizens and the government needs to adhere to the constitutional principles that are there. And this concept also imposes certain obligation on both the citizens as well as on the government. What are those obligations? Now the citizens need to respect the Constitution and they need to respect the government authorities which derive the power from the Constitution. And at the other end, the government needs to adhere to the boundaries being defined by the Constitution and they need to perform their constitutional duties. And if the government authorities fail to carry out their constitutional duties, then the citizens have all the right to hold the government accountable. So, the constitutional morality imposes certain obligation on citizens as well as the government as well. According to Dr. B.R. Ambedkar, constitutional morality basically allows peaceful settlement of dissent between the governing and the governed without resorting to any sort of violent disruptions. Now, the second aspect that we need to understand is what are the sources of constitutional morality? The sources are Constitutional Assembly debates, the fundamental rights, fundamental duties, DPSP, preamble, etc. But as I have told you, you do not find explicit mention of this term in the Indian Constitution. But then also, these aspects are considered to be the sources of the constitutional morality. Why? Because these aspects, the preamble, the fundamental right, fundamental duty, DPSP, Constitutional Assembly debates, they basically outline what would be the core constitutional principles and values which the citizens as well as the government needs to adhere to. That is why these are referred to be as the sources of constitutional morality. Now the next aspect is how the judiciary has over the time interpreted this word constitutional morality. This we'll try to understand by looking at these various case laws. First landmark judgment which made mention of this very term constitutional morality was the Nas Foundation versus Government of NCT of Delhi case 2009, in which the Delhi High Court struck down section 377 of IPC, which basically related with criminalization of homosexuality. In this landmark judgment, the Delhi High Court stated that the judiciary is not supposed to be guided by the majoritarian or the societal morality. Rather, the judiciary needs to be guided by the constitutional morality. So this landmark judgment basically set the precedent that the judiciary is supposed to be guided by constitutional morality and not by the public or popular morality which is there. Then in Navteej Singh Zohar versus Union of India case 2018, finally the Supreme Court struck down section 377 of IPC. We decriminalize homosexuality by adhering to the core constitutional principles of equality, justice, liberty, etc. Then in Joseph Shine versus Union of India case 2018, the Supreme Court struck down section 497 of IPC, Indian Penal Code, which basically decriminalized adultery. What is adultery? Adultery basically criminalized a man for having sexual intercourse with a married woman. For this, the woman is not punished, but the man is punished for this. Why did the Supreme Court struck down this section by adhering to the principle of constitutional morality? The Supreme Court in this very judgment stated that the woman is not a property of man. And in order to uphold the idea of right to equality and gender equality, we need to struck down this adultery section, okay, which is under section 497 of IPC. So by adhering to this constitutional principles of equality and gender equality, the Supreme Court struck down section 497 of IPC. Then in Government of NCT of Delhi versus Union of India case 2018, the Supreme Court stated that constitutional morality is basically the second doctrine of basic structure. And this judgment basically tried to resolve the power tussle which was going on between the Lieutenant Governor of Delhi and the elected government of Delhi. In this landmark judgment, the Supreme Court made a request to both the Lieutenant Governor of Delhi as well as elected government of Delhi, that is the Chief Minister, that you please adhere to the constitutional values and principles which are there in place in order to ensure smooth and efficient administration of the Delhi region. And lastly, in Indian Young Lawyers Association versus State of Kerala 2018 judgment, which is famously known as the Sabrimala judgment, the Supreme Court allowed the women which belong to menstruating age to enter into the Sabrimala temple by adhering to the core constitutional principles and values like equality, liberty, justice and fraternity. And in this landmark judgment, the Supreme Court stated that the word morality that we find mentioned under Article 25 and 26 does not relate to public morality or societal morality. Rather, it refers to constitutional morality. So, through these landmark judgment, the judiciary has tried to interpret the constitutional morality. Now, let's look into the significance of this very concept. First significance is it enables us to uphold the rule of law. How come? As I told you that according to Grote, the constitutional morality puts moral obligation on both the citizens as well as on the government, that they have to adhere to the core constitutional principles with utmost dignity. And it also allows the citizens to hold the government accountable if they found that the government is not, doing its constitutional duties, which it is supposed to perform according to the Indian Constitution. Or if the citizens found that the government authorities are violating the boundaries which have been determined by the Constitution. Then it also preserves the trust of the people in the democratic institutions. Why? This is something we discuss right now, that constitutional morality puts a moral obligation on the government authorities that they have to perform their functions, their constitutional duties within the framework, within the jurisdiction which has been defined by the Constitution. And if they found to, violate that jurisdiction, the constitutional boundaries, then the citizens have all the right to hold the government accountable. They have all the right to criticize the government of the day. Then, the constitutional morality also enables active participation of the citizens in the democratic process. Then, it enables to bring positive transformation in the persisting societal morality. This we can understand by referring to this Nas Foundation case, Navtej Singh Zohar case, okay? Because after these judgments, what has happened? Nowadays, homosexuality is getting normalized in India. So, the constitutional morality enables positive transformation in the persisting societal morality. Okay. Lastly, it strives to create an inclusive society. How come? We can make reference to Joseph Sain case and Sabrimala judgment, wherein in order to create an inclusive society, in order to uphold the constitutional principles of gender equality, justice, fraternity, liberty, etc., we created a more inclusive society. We struck down adultery, which was, violative of gender equality, and we allowed the entry of women in the Sabrimala temple. Again, we upheld the constitutional principle or values of equality. Then, the next aspect that we need to understand is, what are the criticisms which have been given with regard to this particular concept? The first criticism is, as I have told you from the very beginning, that we do not find explicit mention of this term anywhere in the Indian Constitution. So why this is used as a criticism? Because when the term is nowhere defined in the Indian Constitution, now it is up to the subjective interpretation of a respective judge. Okay, that how is he or she is going to interpret this term, and he or she is going to apply that very concept when it comes to giving a verdict. Then, it hinders organic development in the society. Take the example of Sabrimala judgment. Although the Supreme Court has given its verdict that the women of menstruating age would be allowed to enter the Sabrimala temple. But what has happened? We have yet not been able to enforce that Supreme Court judgment. So, this top-down approach is not going to change the societal mindset. Ultimately, we need to work upon educating the people, making the people aware. Okay? And we need to allow the society to go through its organic development in the societal morality. Then, it creates distrust among the public towards the state. Why? Because this term is time and again being used by the judiciary when it is adjudicating a particular case. But the judiciary is not an elected body. So ultimately, on account of this top-down imposition of morality, what is happening? That ultimately the citizens are developing a distrust towards the government of the day. And lastly, in this regard, the previous Attorney General of India, K.K. Venugopala, has pointed out that the judiciary, by resorting to this concept of constitutional morality, is actually practicing judicial overreach. This was something which came in limelight with regard to the issue of legalization of same-sex marriage. In that very issue, the Parliament time and again made a request to the judiciary that you please do not deliver any judgment when it comes to legalization of same-sex marriage. Let the Parliament debate on that very issue. Let the Parliament look into all the different aspects or issues which would be related to legalization of same-sex marriage. And ultimately, it is the Parliament which is the elected body. So, we have the right to take a decision on such issue, not the judiciary. Now, in this regard, what needs to be done? Ultimately, first and foremost, the judiciary should define what do we mean by constitutional morality. And the judiciary should not, explicitly and time and again should apply the constitutional morality to every judgment. It should be cautious of this thing. And ultimately, the judiciary needs to uphold the doctrine of separation of power. And whatever issues are there, we should not go for top-down approach. Let the Parliament discuss and debate the pertinent issues like legalization of same-sex marriage. The judiciary should adhere to the doctrine of separation of power. Okay, it should not practice judicial overreach. This is all that we need to know with regard to this article. Let's move to the next one. Now, the next one relates to functioning of ED. And this article relates to this very topic of your GS Paper 2 syllabus. Let's try and understand the context. So, the context is, recently the Supreme Court has ordered the Chief of Enforcement Directorate to demit his office on 31st July. But in this judgment, the Supreme Court has upheld the statutory amendments which were made in Central Vigilance Commission Act 2003 and Delhi Special Police Establishment Act 1946 in 2021. What was exactly done through the statutory amendments which were done in 2021? Through these amendments, the central government got the power to increase the tenure of the chiefs of CBI as well as Enforcement Directorate for 3 years beyond their fixed term of 2 years. And this extension of 3 years would be allowed only if a particular committee recommend that yes, the extension should be allowed in the public interest. And this extension should be done 1 year at a go. Okay. So, the chiefs of CBI and ED could now remain in their office for maximum period of 5 years. 2 year is fixed term. Okay. So, beyond this 2 year term, the central government can increase their tenure, but 1 year at a time for 3 year maximum. Okay. Now, the thing that we need to understand from the mains perspective is, what are the challenges that we are witnessing when it comes to the functioning of ED? First and foremost, the critics have pointed out that ED is being used by the government of the day to curb the dissent. This we can very well understand by referring to this example that way back in 2020, the bank accounts of Amnesty International were freezed by the ED on the grounds of money laundering. Because we know that Amnesty International time and again hinders the implementation of developmental projects like coal mining projects, like creation of thermal power plants, etc. So it is being pointed out by the critics that the government of the day is using ED to curb the dissent. The another issue is there is very low convictions, especially with regard to Prevention of Money Laundering Act. This we can understand by referring to this data which was given by the government itself at the floor of the parliament. Between 2014-15 to 2021-2022, out of the 888 cases which were investigated by the ED, we witnessed conviction only in 23 cases. Then there are also charges of politicization of ED. In this regard, a member of parliament raised this concern that since 2014 till 2022, out of the 121 political leaders which were probed by the ED, 95% of them belong to opposition political parties. So the critics point out that the government of the day is using the ED as a tool to do political intimidation. Majority of the cases are against the MPs who belong to opposition political party. Then it has limited jurisdiction because it has the right to confiscate the property and arrest a person who is within the territory of India. However, the recent Fugitive Economic Offenders Act 2018 has given the ED the power to confiscate the properties of fugitive economic offenders, who have run out of India because they could be arrested by the police authorities. And lastly, it has been pointed out that it is being provided inadequate funding by the government of the day. Now in this regard, what needs to be done in order to ensure neutral and impartial functioning of ED? First and foremost, we need to put in place a neutral appointment procedure, especially for the chief of ED, like we have in place for the chief of CBI. CBI director is basically appointed based on the recommendation of a committee which consists of PM, CJI and leader of opposition in the Lok Sabha. But when it comes to the chief of ED, it is appointed by a committee which consists of Chief Vigilance Commissioner and the Secretaries of Home, Finance, Personnel and Training. So we need to put in place a neutral appointment procedure like we have in place for the director of CBI. Then this piecemeal extension of tenure should not be there. The tenure should be fixed for 2 years in order to make sure that the chief of ED as well as CBI works in a neutral manner. Then there needs to be a cooling off period. Let's suppose if you want to extend the tenure of the chiefs of ED or CBI, there should be a cooling off period for 2 to 3 years. After they complete their 2-year fixed tenure, then only after a gap of 2-3 years, they should be allowed for to be appointed as the chief of ED or CBI. There should be a cooling off period. Then if at all you are doing the extension of their term, then it should be done based on merit. And lastly, we need to provide adequate funds and staff to the ED so that they could carry out their investigation in the timely manner. And they should also make use of the technology. This is all that we need to know with regard to this article. Let's move to the next article. Now the next article relates to Consumer Price Index, and this article relates to this very topic of your GS paper 3. Let's try and understand the context. So in today's The Hindu newspaper, there was an editorial which pointed out this aspect that the composition of CPI currently is not reflecting the change in the consumption pattern of the Indian society. What has happened? With economic development, our consumption pattern has changed. We no more make use of radios, DVDs, CDs, etc. Okay, but these items are still there in the CPI. One example which was pointed out in the article itself, when it comes to cereals, around 9% weightage has been given to the cereals. But what we are witnessing, that with economic development, the people are shifting towards nutrient-rich diet, like dairy products, like meat products. So this much weightage should not be given to cereals according to the author. And in this editorial, the writer has also made a point that we would be able to reflect the changes in the consumption pattern that we are witnessing currently only if we align the CPI data with the household consumption expenditure survey, which is being done by the Ministry of Statistics and Program Implementation. Now, the first aspect that we need to understand in this regard is, what do you actually mean by inflation? Inflation, means general rise in prices of goods and services, which ultimately leads to decline in your purchasing power. What is purchasing power? It basically refers to the value of a particular currency. It basically implies that how many number of goods and services you are able to buy with 1 unit of currency. You must have heard your grandparents, they would be saying that in their times they used to buy a lot of vegetables in 1 rupee only. But today you are not able to buy a standard toffee within 1 rupee. Okay, so this implies that the purchasing power of rupee has gone down on account of general rise in prices of goods and services. Now, when it comes to CPI, what is CPI? CPI basically monitors the change in prices of a basket of goods and services. Okay, it includes goods like food, clothing, housing, etc. and services like medical care, transportation, etc., education, etc. It basically reflects the inflation from the consumer perspective. Okay, it takes into account that what amount of money you are paying to the merchant in order to buy a particular good. Now, there are different types of CPI which are there in India. There is CPI for industrial worker. So, for these different kinds of CPI, there is different basket of goods and services, okay, which are primarily being used. Let's say when it comes to CPI for industrial workers, those basket of goods and services would be used by industrial workers. A particular set of goods and basket of goods and services that would be used by the agriculture laborers. So change in those prices of those goods which are there in that basket is measured under the CPI. When it comes to CPI for industrial workers, the base year is 2016. For agricultural laborers and rural laborers, the base year is 1987. And when it comes to CPI rural, urban and combined, the base year is 2012. Now, this CPI data is released on a monthly basis. When it comes to these three, it is released by Labour Bureau, which is there in Ministry of Labour. And the last one, that is CPI rural, urban and combined, is released by NSO, National Statistical Office, which is under Ministry of Statistics and Program Implementation. And the CPI data comes on a monthly basis. So how do you actually calculate CPI? As I have told you, in the CPI we monitor the change in prices of the goods which are there in a particular basket. Okay, so we measure that what is the change when it comes to the current prices of the goods and services which are there in the basket, and we compare it with the prices in the base year. Into 100. Okay, let's suppose now we are considering the CPI which is there in July. So the prices of that same basket of goods and services would be taken into consideration that were there in the July month of this base year. Okay, so through this formula you calculate CPI, which basically gives you the perspective of inflation from the consumer perspective. It basically measures the retail inflation which is there. What is the significance of CPI? From 2014, RBI has started taking into account the CPI when it comes to controlling the inflation rate in India. Previously, it used to resort to WPI, which basically refers to wholesale price index. Okay, but from 2014, the RBI has started using CPI to control the inflation. Then it is used for indexing dearness allowances for the employers which are there, and it is also used to revise the minimum wages, especially for the agricultural laborers. This is all that we need to know with regard to CPI. Let's move further. Now, this is the last article that we are supposed to discuss in today's analyst, and this article relates to this very topic of your prelim syllabus. Now, let's try and understand the context first. The context is, last week, the Telecom Regulatory Authority of India has sought inputs from various experts that whether it would be possible to have a selective app bans instead of going for complete internet shutdowns. What do we mean by internet shutdowns? Wherein we completely, block the mobile internet, the dial-up internet connection and the wireless internet connection. And when it comes to India, it has been found that we time and again resort to internet shutdown. The government resort to internet shutdown in order to, curb the spread of misinformation and rumors in order to maintain the law and order situation, especially, let's say, when a particular region is witnessing communal riots. So, in order to maintain the law and order situation, the government resorts to internet shutdown. Now, in this regard, the experts pointed out that it is not possible to completely ban the virtual private networks. The Manipur High Court also asked the expert to look into this aspect, that whether we can go for selective app bans or not instead of internet shutdown. So the experts have pointed out that you would not be able, it would not be technically feasible to completely ban the virtual private networks. Now, in this regard, especially from our prelim stage, we need to understand that what are virtual private networks? They are basically, secure and encrypted connection over the internet. Let me explain it in a very simple manner. Whenever you get an internet connection from the internet service provider, and whenever you log in into the internet service provider is able to see whatever is your online activity, and the websites are able to trace you through your IP address. So whenever you log in into the internet or into a particular website, your IP address would be visible to that website and to the internet service providers, which basically enables the authorities to trace your location at the ground. But what happens when you use a virtual private network? This IP address the government is not able to trace. Why? Because what happens when you use a VPN server, what it does is it creates an alternate IP address. Okay, so neither the government nor the hackers nor the advertisers are able to trace your geographical location actually. Secondly, the VPN server enables you to access the restricted content. Let's suppose in India, if a particular content is censored, okay, so by logging into the VPN server, you can access that restricted online content as well. And lastly, the VPN server plays a very important role in ensuring privacy. How come? Normally, when you access the internet, as I've told you, the internet service providers have all the information, okay, whatever you are doing online. But when you use VPN server, what happens? Your encrypted data goes from here, and this data basically goes through a virtual tunnel. The VPN server basically acts as a virtual tunnel by adding another layer of protection for your data. So neither the advertisers nor the hackers nor the government agencies would be able to look into this aspect, that what you are actually doing online. So this all is the purpose of VPN, that is privacy and security. Anonymity is there because nobody would be able to trace your IP address. Bypassing geographical restriction, it enables you to access the restricted online content by using VPN servers. which is banned in your particular country, and it enhances online security. As I've told you, if you use VPN servers, the internet service provider would not be able to look into your online activity. Okay? And how it also promotes online security, because usually what happens, the internet service providers at times share your online activity with the government authorities or with the advertisers. So VPN server play a very major role in enhancing your privacy when it comes to the online activity, and it enables remote access as well. This is all that we need to know from today's newspaper. Thank you for listening to this discussion, and all the very best for your preparation.